As the SEC versus Ripple case goes on, we see the SEC get exposed again and again. What are the latest leaks experts published about the SEC? And what did John E. Deaton find out again? Stay tuned till the end of the video to find out. But first, we are giving away $500 at the end of the month to one random subscriber to start on their XRP journey. All you need to do is to like the video, subscribe and comment your thoughts on XRP in the comment section. Welcome back XRP Army. As the case progresses, so does the level of expert criticism directed against the SEC. Neither Daniel Weiner nor Amina Hassan of the law firm Hughes Hubbard & Reed wanted a jury to decide whether the cryptocurrency products at the core of a class action lawsuit against their client, former Cantor Fitzgerald Vice Chair Stuart Fraser, constituted securities or not. The plaintiff's case against Fraser, in which they accused him of state and federal securities fraud, came to a close when Weiner and Hassan requested that U.S. District Judge Michael Shea of Hartford, Connecticut, rule that the products were not securities as a matter of law under the 1946 Howey test established by the United States Supreme Court. The judge stated that he would defer to the jury. Weiner, Hassan, and Fraser were able to take advantage of the situation. After a day and a half of deliberations, the 9-member jury reached the conclusion that none of the 4 crypto products at issue in the case qualified as a security, and therefore that Fraser could not be held accountable for securities fraud. The verdict was announced late Monday afternoon. As part of its decision, the jury also dismissed the class's common law fraud allegation, giving the former Wall Street executive a comprehensive defense victory. With the ruling, Weiner claims that a jury has been asked to consider whether Bitcoin goods, such as a supposed digital token called Paycoin, should be subject to securities regulations for the first time in history. As you are aware, this has been a source of heated debate in the proceedings brought by the Securities and Exchange Commission against high-profile cryptocurrency defendants such as Ripple Labs Inc., Telegram Group Inc., and Kick Interactive Inc. 2 federal courts, including United States District Judge Alvin Hellerstein of Manhattan in the SEC lawsuit charging Kick of selling an unregistered security in an initial coin offering, have determined that digital assets are securities under the Howey test, according to a report by the Financial Times. The jury judgment in Fraser's case is in direct conflict with the SEC's appraisal of one of the crypto products at the center of the class action lawsuit against the SEC. Jurors heard from Weiner, who also informed them that the fraudulent crypto goods, which included the hashlets that were classified as securities by the SEC, were not, in reality, securities under the jury instructions given to them by the judge. As an example, he stated that one of the items was just a digital money wallet. Another was just a shop credit that might be used in the future. Weiner explained that the token, Paycoin, was a form of currency. In addition, he contended that hashlets did not fulfill the requirements set forth in the jury instructions. When I asked Weiner about his hashlets defense strategy, he stated it all came down to testimony from 2 of the named plaintiffs, who claimed that their individual actions may have an impact on daily income in different crypto mining pools. As a result, Weiner claimed to jurors that hashlets did not qualify as a common operation under Howey since choice and direction remained with the customer. According to him, in addition, the product did not fulfill the Howey condition that profits be generated purely from the labor of others because individual decisions made by investors influenced their gains. In response, class attorney Buchdahl underlined that the United States government had determined that hashlets were securities, and that his side would be delighted if jurors agreed with the government's conclusion on the matter. In Weiner's words, "It seemed absurd to us that a jury should be called upon to decide this." The SEC and Department of Justice's descriptions of cryptocurrency offerings, however, were not sufficient, according to him, to protect the class. The jury didn't buy it, Weiner stated. The primary plaintiff's attorney, Buchdahl of Sussman, stated in an email statement that they are weighing their options. According to Buchdahl, "We are disappointed in the jury's finding that hashlets were not securities, which is contrary not only to the SEC's official position, but also to the overwhelming weight of the evidence. Given that we don't know exactly why the Fraser jury determined that hashlets, Paycoin, and the other crypto products in the case were not securities, future crypto defendants should probably not jump to the conclusion that they'll have a better chance with jurors than they will with regulators or judges. However, the Fraser decision will undoubtedly provide them with food for thought." A group of 9 ordinary individuals examined the identical data as the SEC and the DOJ and came to a completely different conclusion regarding whether cryptocurrency goods were securities or not. That represents a watershed moment. It all demonstrates how uneducated and arrogant the SEC is, especially when it comes to wrongly defaming Ripple. Comment, XRP Army, if you believe Wiener is right. In addition, the well-known activist John E. Deaton remarked on all of this on Twitter, exposing the SEC's deception even farther than before. By the way, do you think Deaton is right? Let us know in the comment section down below. And there are many more specialists who are speaking out against these misdeeds. Commissioner Hester Pierce of the Securities and Exchange Commission recently appeared at the Texas Blockchain Summit, where she offered suggestions for the future of cryptocurrency regulation. The official is well known for being a vocal opponent of the agency's strategy of enforcing regulations in the digital asset industry by enforcing them, the lack of clarity in the ecosystem, the role of the SEC for investors and jurisdiction, and the necessity to acknowledge that if something is decentralized, it is outside of the SEC's authority were all discussed in the address. We will concentrate on the second section, of 6, of the discussion, which asks, are we enforcing rules by settling or are we settling for ambiguity? Although the entire discussion is pertinent to the digital asset business, we will focus only on the second portion. Using Supreme Court precedent and our own expanding record of enforcement actions, the SEC declares that the matter is concluded and that the vast majority of digital assets are securities. If we accept enforcement as a legitimate means of providing clarification, it is clear that this approach is not functioning. Definitive determinations of securityness have only occurred in the few instances in which a court, rather than the Commission, has decided the matter. Even in those instances, a determination that a token was offered initially as a security does not say anything about the token itself being a security, either at the time of the initial sale or in secondary transactions. Do you agree that the SEC is scamming Ripple? If yes, then make sure to like this video. In the context of the SEC versus Ripple litigation, this is the case. The blockchain startup has been taken to court by the regulator on the grounds that it allegedly offered and advertised XRP in the form of an investment contract, often known as a security. Ms. Pierce, on the other hand, has not and will not directly reference Ripple since SEC officials are not permitted to publicly comment on current SEC litigation. It is anticipated that this lawsuit will likewise be resolved by a settlement rather than a judicial decision. So far, history has proven this to be true. Most of our crypto enforcement actions, however, have not been litigated actions. Rather, they have ended in settlements, which are not good vehicles for careful legal analysis. When a party settles an SEC enforcement action, it often is trying to get the case wrapped up so it can move on. It has no incentive to force the SEC, as a condition of the settlement, to lay out a clear legal analysis. All of this shows that the SEC is just straight wrong in the way they discredit Ripple and should stop the case immediately, or they'll get exposed even more. What do you think about the SEC's behavior? Do you think the SEC should be sued for it? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.